jurisdiction. I believe it was in late 2008 I received a letter apparently from Carmel Wiseman under Law Society letterhead informing me of the court order she had secured, which bore a name similar to mine but different in many important respects. That letter did not state that I was affected by the order, but was craftily worded to cause the average recipient to believe otherwise. I am not the average recipient, and I saw her deception at play. A few weeks later, I learned that the police were actively investigating me, apparently to determine if I was in contravention of a court order. At this time, I was in reasonable fear for my safety, realizing that the police might use excessive force when arresting me in order to punish me for my lawful political and lawful activities and legal activities. I was aware of the tasering death at the Vancouver airport and the unlawful beating of Cal Washington's brother at the hands of the RCMP, acting on an unendorsed warrant created by James Wingham during a matter to which I had tried to act as agent. At that time, I started to fear for my safety, realizing that although my actions were lawful at all times, there seemed to be people in the Law Society of British Columbia, the courts, the police, and the government who were not acting legally nor lawfully, and as I was speaking and acting aggressively against them and their deception, began to believe that they may be targeting me for punishment, masquerading as legal enforcement of a lawful court order. However, I did not and do not believe that order was lawful, nor that enforcement of it would be legal. In order to ensure my safety, I moved to Victoria on Vancouver Island for almost a month while I addressed the situation, and at that time informed my friend with whom I was staying of my fears and concerns. His affidavit will be included. It's not yet. I addressed those concerns using the court of public opinion and by making some phone calls. Specifically, I phoned Carmel Wiseman and recorded our conversation. She acknowledged that she was incapable of identifying the party affected by the order and could only state that they had secured an order against some party named the respondent Robert-Arthur Menard of North Vancouver. That is a title, name, and designation I have not accepted, nor did I ever empower anyone to name me. An examination of the Public Notice Board operated by the Law Society of British Columbia via their website fails to reveal the order in question being posted, although it can be found in the Bencher's Bulletin section online. On the Public Notice Board section, there is a note explaining that one item has been removed when new information came to light, and I believe that new information and what was removed has bearing on this issue and needs be disclosed by the Law Society of British Columbia in order for justice to be served. As of the date of this action, I am aware that the Law Society of British Columbia and Carmel Wiseman specifically are in the habit of using the Legal Profession Act against members of the public when they either know or should know that it is not lawfully applicable to people who are not lawyers and members of their society. It is my firm belief that when they tried to use that act against me, they either knew or should have known that they were applying the restrictions found within that act outside the mandate and applicability of that act. I have deconstructed and examined Section 1.1 of the Legal Profession Act titled Application, and I am confident that I can establish before a proper and independent judicial justice of the peace that the Law Society of British Columbia and Carmel Wiseman specifically have been misapplying the Act and have harmed me by so doing, in that they did cause me to believe my life was potentially endangered and they hindered my lawful commercial and private activities. Furthermore, I believe that they engaged in extortion when trying to secure an agreement with me, and when I did not buckle under and bow to their intimidation tactics, they committed a fraud upon a court and perverted the course of justice in order to maintain their extraordinarily lucrative and unlawful monopoly on the justice system in British Columbia. It is my claim that Carmel Wiseman harmed me by unlawfully and illegally limiting lawful opportunities, slandering me by implying I was identifying myself as a lawyer, publishing or causing to be published information which could reasonably cause others to believe I was subject to a court order barring me from providing lawful services which they wanted me to provide, causing me emotional and spiritual harm by creating a situation where it was reasonable for me to fear for my safety and physical welfare, and she did so by misleading the police into conducting an investigation against me which may have led to a violent and unlawful arrest. And she eroded and diminished my respect and faith in the courts by securing an order in what appeared to be an unlawful manner with the collusion of the courts. It is my claim that the only way justice can be served in this matter is if a judicial justice of the peace who has never been a member of the Law Society of British Columbia conducts a proper judicial review in small claims court of Section 1.1 of the Legal Profession Act to determine the applicability of the entire Act, as well as examining the harm and potential for harm caused and created by Carmel Wiseman and the Law Society of British Columbia, and awarding suitable damages to me in the amount of $25,000 for actual, exemplary, and punitive damages. Dated December 10, 2009. So that's my argument that I'm going to bring. Quite certain that Section 1.1, when properly examined, will reveal that they simply never had the right to enforce that body of words against someone who is not a member of the Law Society. And what we're going to do is we're going to use the High-Tech Board of Truth and Justice here in just a moment, and I'll explain to you my argument and why I'm so confident that I'm going to win this. Now, the first thing we're going to be looking at here with the High-Tech Board of Truth and Justice with redesigned letterhead, see, I respond to complaints. What we're going to be looking at is Section 1.1. of the Legal Profession Act. Now, you will see that there are two ways we can interpret this section. Starting from here, we're going to get to interpret it either one way or another. It's essentially a Y in the path. And this is where the lawyers have to choose. Either they go this way or they go this way. Now, if they interpret it one way, they will be serving us. If they go the other way, we serve them. This path gives them very little power and control over us. This one gives them all sorts. Now, strangely enough, where we find our problem between myself and them essentially is at this point right here. I believe they should interpret it this way, and they should be serving us. They believe it goes this way, and we are their slave. So what we have to do is we have to examine that. Now bear in mind, it can be fun, but it likely won't be all that easy. You'll find that they do use more than a little bit of deception to try to get us to accept this position right here. But what if the proper way to interpret that section results in this, them serving us? And what if the interpretation of Section 1.1 of the Legal Profession Act results in the truth being known, and that is, the Legal Profession Act cannot be applied against someone like me who is not a lawyer and a member of their society. And therefore, when they sought a court order, well, they were simply wrong to do so. Now imagine this. This is the very first step. This is the first section of the first act that they must determine. This is number one. The way they interpret this issue right here is going to determine whether or not they do in fact fulfill their duty to preserve and maintain the public interest in the administration of justice. This path over here, we have no interest. We're their chattel property. We're like their cattle. And this way, we do have great interest. 11,000 lawyers in BC, and what if not a single one of them could interpret it properly? Would you trust them to act in the public interest for anything? Let alone, from this point on, being the ones who will interpret all these bodies of words that they claim are our laws? Now, my interpretation, you'll see, is going to point to this side, and you will see that it will require zero assumptions. I will not have to abandon logic, reason, or law. Logic, reason, and law. Check. And it doesn't offend the sense